All right. Move camera around there. Good morning, everyone. Oh, it's not using that camera. Darn it. I have a camera on over here that it's not using, so I apologize for looking in the wrong direction towards it. Tracy, can you hear me? And I apologize. As you can tell, I'm getting a little bit of a cold here.
Oh, good morning. I can hear you. Oh, sorry.
Okay.
Yeah, wow. Tracy, I apologize.
Okay. If I become too unhearable, just tell me. But we'll get started here. Today is May 23rd, 2024. I'm Administrative Law Judge Robert Garvey, who is suffering from a bit of a little cold. So I apologize if my voice goes out on here. This comes on actually for a kind of discussion on motion to compel that was filed late last week. I'll start with appearances and we'll go in the order. And if I miss somebody, I apologize. I'm going to say CenturyLink, staff, UCA, CCTA, LETA, CCOA, and Best 911. Go in that order for me.
Morning, Your Honor. Sorry about your cold. Tom Snyder on behalf of Lumen. With me today is Tim Kunkelman, one of the regulatory managers.
Good morning, Your Honor. Justin Cox with the Colorado Attorney General's Office on behalf of trial staff. I'm joined by my colleague, Josh Horman, as well as Jennifer Kirkland from trial staff.
Your Honor, this is Tracy Oldemeyer. I don't know that I see UCA.
I don't see him either. No. And it's not really necessary that they're here today, but okay. UCA has not appeared. We'll move on to CCTA.
Good morning. This is Abby Briggerman on behalf of CCTA.
And good morning, Your Honor. This is Tracy Oldemeyer appearing on behalf of LETA and the CCO.
Okay, and who's ever appeared? I guess you guys want to be Best 911, and so we'll just call you Best 911. And so make your appearance for me.
Joseph Benkert on behalf of Best 911. My client is the Boulder Regional Emergency Telephone Authority. Bart Miller is also here on behalf of his clients.
Okay. First, a little house cleaning for me. The open motion for the waiver of, and I forget the rule right now. Some things, and I apologize for the other thing I got to speak to is the length of time it took for the decision after our last pre-hearing conference come out. I don't know if you're aware of this, but I just returned to the commission about 2 or 3 days before that hearing. The IT staff here with the commissioner of the state was not able to get me Word or Office for a week. So I couldn't even start on writing anything out for a week after that. So that delayed some, and there's some other issues after that. I got a bunch of other cases and things backed up there. So I do apologize for that. That's much later than I like to get those things out. And because I anticipate other issues, especially with my cold right now, I did have time to look at the motion for the waiver. And I'm going to tell you what, the decision will come out, and in it, I'm going to grant the waiver. I just want to give a little bit of reasoning and how it's going to be a little bit different, just so you understand that. I believe it's centralized to that, to the rule that we're here for on this case, which brings up this proceeding. In the waiver or the motion, the unopposed motion, it was a request to basically move the date from August 1st to, and I'm going to say the 19th. I don't really recall what the date was offhand. In my previous time with the commission, I had gotten into numerous conversations with judges who no longer are here, Judge Gomez, who is now commission counsel, and also with Judge Jennings Fader, about if you could waive a date If there's a 250-day deadline in order to get something done by, if you waive that, can you waive that to a different date? So you make it 275 days, or do you just waive it, or does it just go away? I was under the impression with Judge Jennings Fader that you can't move it. It almost becomes a new rulemaking if you do that. It's not waiving the date as much as it is making a new rule and changing the rule. You can, in my opinion, you either waive the date and it goes away, or you don't. So I can grant the waiver on that, which will not put that date on there. That date just goes away. But the one thing I do want to make stress out of this is that does not necessarily mean that if the projects in this proceeding are approved, we'll say August 15th, that that necessarily gets these projects into the following proceeding that the commission would hold that opens up August 1st. I think you still have to ask permission to do that and say that they can, that they're not barred by this rule from being considered. But I think it will be up to the commission to decide whether they want to take them on at that time. Because also if it's not done until September 15th, maybe that's too late. But we'll see that. So I just want to explain that rule. So I also want to stress one other thing. That doesn't change my perception of this case or the speed with I think this case needs to be done. Just because we have that rule and I'm taking that off, that's not going to change my opinion. I understand this case has been laying around for a long time. You guys want this figured out. You want this to go forward. There's public safety issues that are involved in this case, and we want to move that forward. So that's the ruling that's going to come out on that motion that's out there. Are there any questions about what I said there?
Not from Lumen, Judge.
Okay. And I'm not seeing any, but I just want to give you a heads up. That's going to come out with the holidays and with honestly me feeling kind of crappy. They might delay it a little bit. Brings us on to the motion to compel. I'm pretty sure I know what I'm going to do in this motion to compel. If either of the parties would like to make any kind of short statement for, if you go more than 5 minutes, I'm going to cut you off. Ms. Oldemeyer, it's your motion. Do you wish to speak anything more, or will you let the filing speak for itself?
I do, Your Honor, and with your leniency, I'll stick to 5 minutes, but I just wanted to emphasize the disagreement about the scope and the interpretation of Rule 2143. We cite, Your Honor, back to Rule 2143A, which shouldn't be skipped over in the judge's analysis. And that means that the BESP shall take reasonable measures to provide reliable basic emergency service. And that's what our discovery requests really focus on. Then there's an including in a laundry list. And Rule 2143A goes on to address physical and geographic diversity, both of which are important. What this proceeding is about is improving the reliability, diversity, and resiliency of basic emergency service, and the network or the portion of a 911 call flow that is regulated by the commission. That's the aggregation, routing, and transport of the calls. And the premise of the entire 911 system is that a 911 call routes to the PSAP, able to dispatch the first responders for that caller's emergency. And that's what's regulated here. And we're talking about an application of an entity that has a certificate granted by the commission. And we think analyzing this proceeding under Rule 2002, which is broader, in addition to Rule 2143A and B, are important. Where CenturyLink argues this is a streamlined approach focused on just the 5 projects, the interveners I represent do not agree with that. And the intent and purpose of the goals of the new Rule 2143 have been in the works for years. As you mentioned, Your Honor, while this proceeding has been open for a while, the particular plan at issue was just filed in February of 2024. We are talking about avoiding outages in 911. the 911 stakeholders cited in our motion to the separate rulemaking, clarifying the rules regarding outages. We don't want Your Honor to be distracted and have blinders on. We believe this rulemaking or this proceeding has to be considered in light of the others. So we believe that we should be working together as a 911 community for cost-effective solutions that address the root causes of actual outages we've experienced in Colorado. The discovery at issue is focused to those particular issues. In addition to CenturyLink's status as the basic emergency service provider and the service that it is providing. It is not a rubber stamp of the projects they proposed, but rather a really good discussion of what is the primary path call flow. If you want a secondary path, a new fiber build that's going to cost millions of dollars, why do you need to own it? Why didn't you look at third-party facilities that might be more cost effective? Where are single points of failure in your central office? Why aren't you using carrier neutral locations nearby to create that diverse geographic and physical path? So, Your Honor, we emphasize that CenturyLink enjoys a role, a very important role. We are trying to be good partners and work together to improve the basic emergency service network. CenturyLink enjoys this monopolistic role since has had it for over 20 years. And in those 20 years, we moved away from landline phones. There has been a huge impact. Everybody sees the value of delivering 911 calls in IP format to PSAPs. There is billions of dollars being spent on fiber, and we want to provide a solution to improve the network holistically, looking at all the pictures. So we're looking for fundamentals, maps of the primary path call flow. If they don't exist, we want the commission to know they don't exist. And are we using citizens' money? Citizens will ultimately be paying for these projects, using every dollar to the highest and best use. So our discovery goes to that. Specifically, Your Honor, what we have open are, we need verification pages for the answers to interrogatories. What has been unresolved as listed in Exhibit 1, our request for production number 7. And there's a reference to Intrado. There are multiple Intrado entities. There's the Intrado, who's a subcontractor for the call taking system ECATS. And there's an Intrado that is a subcontractor for kind of that Annie Alley portion. We are entitled to those agreements and the service level agreements because when we have finger pointing during an outage between CenturyLink and in the Intrado tax, we need to know who's on first, who can touch the equipment, who can't. We ask that Your Honor order CenturyLink to reply to requests for admissions 1, 2, 3, and 4. Interrogatory number 6, again, with respect to the Intrado entities. And then on interrogatory number 21, we would just like a date certain by which CenturyLink will further supplement that response. Thank you, Your Honor.
Mr. Snyder, do you have any response?
Yes, thanks, Judge. So quickly, there was a reference earlier in Ms. Oldmeyer's discussion about they just needed information concerning why CenturyLink would not have explored all other opportunities related to the fiber builds, and we have 2 fiber builds that are at issue here. We have not objected to that type of discovery. We've answered that discovery, and we'll continue to answer that type of discovery. So I think that's a red herring. And then when Ms. Oldmeyer listed the specific requests that are at issue, those weren't included. So I just want to put that aside. I think that, you know, the Lita's motion, that presentation did, you know, a good job of explaining how there is a fundamental disagreement between the parties as to the scope of this proceeding. There may be other vehicles, you know, under the umbrella of regulation and the commission's jurisdiction to explore the issues that Lita has raised, but this is not that proceeding. Our view is that this is a proceeding under 2143B. 2143A does not have anything to do with this proceeding. that our requirements under that Lumen's requirements as the BSP under 2143B were to meet informally with stakeholders prior to filing its application and identifying the projects at issue. It did that. There's been no accusation. It has not. So the discussions with the 911 community did occur. As Your Honor knows, the projects were proposed. And as you know from our brief, our view is that the scope of this proceeding is to analyze the cost efficiency and effectiveness of the 5 projects that were proposed. To the extent that there weren't projects proposed, that can be set aside for a separate discussion under 2143B for the next round with the informal stakeholders. If the LEDA or others believe that there can be more done that is not being done, there may be other vehicles under the commission's rules to bring that to the commission's attention. But from our perspective, this is a very narrow proceeding, and we do not see any relationship between the Entrado agreements and the 5 projects at issues. And I'm not sure that linkage was really established either in the motion or in the presentation here today. And I would just conclude by saying, reiterating that there was thankfully only 8 discovery requests of the significant number that were served on us that are at issue, and my understanding is 4 of them have been resolved through supplementation. So we really are only talking about 4. And those are requests for production number 7, which is the Entrado contracts, and requests for admission 1 through 3, which are requests that we provide information concerning maintenance and inspection schedules with respect to existing BES, the network. And I'll just reiterate, we do not view that these requests have anything to do with the 5 projects at issues. And while it may seem like it's not a big deal to compel us to provide that type of information, I feel like the client feels this is a slippery slope. Once we start getting and producing information and testimony and evidence beyond the scope of the 5 projects, it's going to be hard to identify a stopping point. So we've drawn a line in the sand with respect to this discovery. We've tried to be cooperative, and I think that's reflected in the fact that we don't have that many disputes, but we really want to keep our arguments and evidence focused on the 5 projects. So that's all I have, Your Honor.
Okay. First off, I want to thank both the parties. I did read in the motion and what was written there that should work together. And as Mr. Snyder mentioned, that at least half of the discrepancies have been taken care of before it even got to me. So thank you. I do appreciate that. As I mentioned a couple of weeks ago, judges hate these things and don't like to get involved in them. So the more you can do that way, the more I appreciate it. So please know that I do appreciate that very much. In reading through the motions and hearing the arguments today, I'm going to deny the motion to compel. I agree with Mr. Snyder. I believe this is 2143B is about these projects. It doesn't go any further than that. I also agree that we want to try and limit. Discovery shouldn't be unlimited on this. The Entrado contract, this is the one thing that I bounced on right away and didn't see there's any relationship, nor did the motion that was LEDA's motion tie together how these projects were related to that at all. I just don't see it at all. I think the party's done a good job of trying to get the discovery together. I don't think it goes out that far. I think this proceeding is limited to these projects and what these projects have going on. And I agree that there was probably other proceedings that the commission will come up where many of these other aspects can be brought up, but this is not the one to do it. This is the one to get these projects together. And I don't see any correlation between the discovery requests of LEDA and these projects. I'm going to deny the motion to compel. That'll come out in a written order as well. But again, I wanted to do this right away for you guys so you'd know. Any questions, Ms. Oldmeyer?
No, Your Honor.
Mr. Snyder, any questions?
No, Your Honor.
Okay. Again, like I say, I'll get out a decision, either 2 decisions or 1 decision with both of these on them. Hopefully it'll be probably sometime next week.
Your Honor.
Yeah, Mr. Cox, sure.
Yeah, Justin Cox, on behalf of staff. Just for some clarification, you mentioned you believe that, or you agreed with CenturyLink regarding the scope of the proceeding and limiting to those 5 projects. And this has come up in other responses that CenturyLink has made, particularly regarding the Telluride Norwood project. That is in the application. And direct testimony, it's mentioned that they plan to withdraw it. And the rules do provide for explanation by CenturyLink related to other projects that have been considered. Is it Your Honor's view that those other projects that have been considered would not be within the scope of the discussion?
Yeah, it's a hypothetical, which judges are never big fans of hypotheticals on there. But the project,
I asked because we staff has discovery out related to the Telluride project, and I know Lita had some as well. So just for clarification, because it could come up, and I know the narrowness or the shortness of the time period we have in the proceeding.
is the Telluride one the one that's going to be withdrawn? I mean, until it's withdrawn, I think it's fair game. I mean,
Yeah, they mentioned it would be, sorry.
I don't think you can say, hey, it's going to be withdrawn and we're not going to give you any discovery on that, and then you don't withdraw it. So until it's withdrawn, it's certainly fair game and part of discovery, I would say. So,
Judge, just to clarify that, yeah, we don't intend to any longer support it in this proceeding. We're not going to file an amended application to withdraw it. We're just not going to support its build. So without evidence, I don't know that it can be granted, but we did not intend to object to staff's discovery requests on that. We for a variety of reasons, we view it as acceptable within the scope. So we are going to answer those questions.
okay. Yeah, no, that's the way I would see it, at least. And you don't have to file anything to withdraw it. But like I say, since it's in part of the application, I would think it would be open for discovery. But again, no discovery questions till we have a problem. Let's wait till the problem occurs. Okay. Anyone else have any other questions or anything?
Yes, Your Honor. Joe Benkert here.
Yeah.
Section 2143B, Roman numeral 1B6 of the rules does provide, as Mr. Snyder had referenced, that there is supposed to be consultation between the BESP and stakeholders prior to selection of the projects to go forward. And part of the problem is if there is not an opportunity for discovery during that consultation, then it winds up being meaningless in terms of being able to find out the information, some of the information Lita has been seeking to help decide what other projects are available and decide the priorities. And so that's what we had suggested. A bifurcated proceeding would be preferable, where we would be able to do discovery before the projects are selected. After projects are selected, then discovery is on those projects. This proceeding, as I understand the rules, is to stay open because CenturyLink can file amendments to its plan, and it can amend its plan after 2 years for the next plan. And so what we'd like to see is once we get through getting these projects approved or considered, that we would be able to have some discovery of a broader nature to learn what we need to learn about what other single points of failure in the network are out there, prioritize them, and be able to have more meaningful consultation.
Well, we're not there yet, I don't think, based upon what you're telling me. So why don't we wait till we get there, and we'll see what happens at the end of this proceeding. But that almost sounds like
it would be on the horizon.
Yeah, I mean, I'm not sure how that would work out, or if that'd be almost into another rulemaking. Mr. Snyder, do you want to make any response on that? I don't think you really have to, but.
Yeah, and I think just from a procedural perspective, Judge, I don't think we would agree to anything like that. I don't think bifurcating an application and granting it and then keeping it open to seek additional discovery is probably appropriate under a 2143B application. And I just, procedurally, I'm not taking the position here that CenturyLink would be uncooperative in the proper process in facilitating that type of discovery or discussion. I just don't, I think it's premature to discuss it. And I just don't, and thinking about a bifurcation, I don't think that's the solution.
Yeah, no, it's certainly not the solution today. That ship sailed if you're going to bifurcate anything on this particular proceeding, but we'll see where it goes later. Well, I keep that in mind, Mr. Benkert. Thank you.
Thank you.
Anything from anyone else? Other than that, no one has anything else. We got a procedural schedule. I'll look for stuff. I thank you. Everyone have a fun, healthy Memorial Day weekend, which it does not appear that I will be having. But I thank you, and look for those orders sometime, hopefully next week. So, all right.
Thank you, Your Honor.
Thank you
Thanks,
very
Judge.
much.
Thank you.
Bye.